Welcome. We'll start at 10 o'clock on the dot. That's the start point we're going to aim for. So we'll just be paused for a couple minutes as we let people join in. Thank you for attending. Today we're going to be talking about contingent rights and contingent obligations. I'll get more in depth on that, I promise. We have a full slideshow for you. Um, And then at the end, if there's time, we'll have as many questions as we can. I believe in the background, Jeremy Rogers, one of the staff attorneys at Oregon Realtors, the director of legal affairs at Oregon Realtors, will be answering questions as well. I'll do my best to answer questions as we go along, at the same time as Jeremy, but he might just answer them before I get to the questions. So feel free to post your questions in the Q&A if you've got questions. Chat generally also has questions posted in it, but it's easier if you put them in the Q&A because I don't lose them in the shuffle of the chat. So if you got questions, put them in the Q&A function. Hopefully everybody's having a good St. Patrick's Day. Hey, there he is. Okay, about a minute left to go, and then we're going to start up this presentation, and we will start talking about the most exciting of things, forms, specifically contingent forms. Oh boy. All right, I see 10 o'clock on mine. I am going to start this thing off then. Let's get this show on the road. So, my name is Nicholas Peasley. I am one of the staff attorneys at Oregon Realtors, one of the people that had a hand in drafting the various forms that are part of the Oregon Realtors Forms Library. Today we're going to be talking about specifically contingent rights and contingent obligations. In our form library, these are forms 2.10, 2.11, and 2.12. 2.10 is the contingent right to purchase, the buyer's contingent right to purchase. 2.11 is the attached form that goes with that contingent right to purchase, that is the notice of intent. And 2.12 is the contingent obligation to sell, the seller's contingent obligation to sell. We're going to cover all of those. We'll do it in depth, I promise. If you've got questions, put them in the Q&A. At the end, we'll also have time for questions and answers as well if you've got other questions that bubble up to the surface as we do this presentation. So let's go. Now you'll note the first image is dominoes. That's because a contingent right is largely something that you could describe as something that causes a domino effect. If your contingency falls apart, it sets the dominoes in motion, and it can cause the failure of many other elements of the contract, if not the whole contract. We'll start with definitions. The definition of a contingency is something that must happen or must be successful, or the contract will not be valid. So the best example of that is the usual contingencies, the inspection contingency, the loan contingency. The one I've got on screen is the loan contingency. The buyer, under the purchase and sale agreements, has to qualify for a loan. If you're using a loan, you have to qualify for that loan. That's the loan contingency. If the buyer fails to qualify, if the property fails to qualify, if the appraisal comes in low and the lender withdraws their approval of that loan, that contingency has failed, and at that point the contract can be called off. It essentially is it's a kill switch, that if this contingency does not work, then either party can just say, turn off the lights, it's over, this contract does not work anymore. In the Oregon Realtors contracts, one thing that is worth noting, this is kind of aside from the presentation we're doing right now, but one thing worth noting, when a contingency fails in the Oregon Realtors contracts, that allows a party to invoke a termination to end the contract, but it doesn't automatically terminate it. We've removed the automatic termination from everything except for the purchase and sale agreement for commercial transactions. Commercial transactions tend to be a little more sophisticated, and they tend to have more of an understanding, kind of the hard and fast lines that occur on these things. For all of the other purchase and sale agreements, our contingencies do not automatically end the contract. Instead, when a contingency fails, the parties are allowed to terminate the contract. So it invokes or grants you a right to end a contract when a contingency fails. Now, with that contingency, we're going to have some language that kind of floods together in this. A contingency is something that has to happen or be successful for the contract to be valid. We also, in the contract, define contingent funds. Contingent funds are money that will belong to the buyer with the uncertain occurrence of a future event that is outside of buyer's control, such as money gifts or proceeds from lawsuits or a year-end bonus. The classic example of that is, if you're trying to purchase a house and you say, yeah, my uncle will give me $100,000 to buy this house. Don't worry, my uncle's good for it. your uncle might not be good for it. Your uncle might not want to give you that $100,000. So that is a contingent fund. It is a fund that is not certain, and it's something that the entire contract is contingent upon. Contingent funds are those funds that are not necessarily guaranteed. Now, why do we bring up contingency and contingent funds? Because when we talk about a contingent right or contingent obligation, it's worth noting that these both are contingencies, and in the case of a contingent right to purchase, it is also a contingent fund that is involved. I'll get more in depth on that. When we talk about the right and the obligation, there are two ways that this goes. Contingent right to purchase is where a buyer makes the contract contingent. They link the contract to the buyer's successful sale of the buyer's own personal home. The buyer basically says, I don't have enough money now, but once I sell my home, I will have enough money. And that contingent linkage on that essentially is why, because the buyer does not have enough money if their home doesn't sell, that is why we make it contingent upon the sale of buyer's home. Essentially, it's a mandatory thing to have happen before the buyer is able to purchase the property. There are some ways that we'll get around that. I'll point it out as we go in the presentation. But in general, the contingent right to purchase is for those situations where the buyer does not have enough money to purchase unless this other thing happens. And so you link the end successful result of your current contract on the successful end result of a different contract. Buyer generally does not have sufficient funds. That's when we talk about this. On the contingent obligation to sell, it's on the other end of the spectrum. In this case, it's when a seller makes the contract contingent. They link the contract to the seller successfully finding a new home for the seller to occupy after closing. So essentially the seller says, I don't want to live in a motel for 3 months in case, after I sell my house because the market is crazy right now. I want to make sure I have a home that I can buy, that I can live in. As soon as I'm out of this home, I want into the other one. Now, that's not all sellers. Some sellers are okay with the idea of, moving across country and spending their money on the next house that they find, and they can make it work for some time afterwards. But a lot of sellers will want to have a place that they can move into upon closing, because they don't want to spend a couple months in a trailer or a travel trailer or that kind of thing during that process. Sellers generally don't have anywhere to live when they use these. Now, sometimes they will, and you can still make it a contingent obligation to sell, but that's an aside. But just know, contingent right to purchase, buyer generally doesn't have enough money to purchase the property unless they sell their own house. Contingent obligation to sell, seller doesn't have a place to live until they buy a new house. We're going to start with talking about the contingent right to purchase. You'll see these little clip art things. In a handful of cases, it's remarkably difficult to illustrate an abstract concept with clip art, so I'll talk about what they mean. In this case, what we're talking about here is a seller and a buyer the buyer wants to purchase seller's property. You're making this a linked contract with a buyer selling to buyer squared, the second buyer, somebody else, and this is based on the sale of buyer's property. So you're linking your property sale to another property sale. Contingent rights to purchase are contingent contractual provisions that base the contract upon a contingent fund. So it is a contingency wrapped in a contingency. It's kind of the turducken of contracts at this point. If the buyer doesn't sell buyer's home, the buyer can't purchase the property. They don't have enough money for it. But the sale of buyer's property is not entirely in the buyer's control. So that's why we talk about it being contingent. The buyer can't necessarily guarantee that the second buyer, the third party buyer that wants to buy the buyer's property, that's going to work. So it's out of the buyer's control and it's out of the seller's control, which is why we put these contingencies in place. A contingent right to purchase is inherently risky. It adds risk to the contract. It requires the seller to essentially agree to a deal that can fall through no act of the parties in this contract. The buyer and the seller might be just perfectly honorable and reasonable people, and they will be doing everything they want to do, and they'll be doing it right. And that's fine, but the buyer's prospective buyer might be someone that's untrustworthy, and they forge a banknote, and that's the reason why buyer's transaction falls through. That riskiness, the fact that their deal might fall through because of the acts of a third party that the seller had no contact with, is why we talk about this being inherently risky, and why we generally put in additional protections for sellers on these contingent rights that allow the seller to proceed with a transaction despite the risk that is kind of audible in this process. We're going to talk about various provisions in the contract. So in this case, these are all contingent right provisions that we're going to be talking about. But in this one slide, I'm going to show a whole bunch of stuff from the purchase and sale agreement. So for a contingent right to purchase, if the buyer is using a contingent right to purchase or otherwise will not have sufficient funds to purchase the property until the buyer sells their own property, the contingent nature of those finances must be disclosed. This is in the purchase and sale agreement, sections 26 and 28. If you're looking on form 1.1, it's lines 82 through 85 and 117 through 121. Line 26 essentially says if the buyer is using a loan, They have enough money to make the down payment. And they also represent that they're not relying on contingent or non-liquid funds for that down payment or the closing costs. So if you're a buyer that says, yeah, don't worry about it, I'll pay it for it alone, and I can put $50,000 down. If that $50,000 comes from the buyer selling their home, the buyer needs to disclose that. They either do that in a general addendum, if it's non-liquid funds, or if it's some bizarre other kind of contingent fund. If it's in a contingent right to purchase context, you want Form 2.10. That's what's going to provide all of the undergirding background information that you want to kind of protect yourself in this context. I see a hand up in the attendees. I don't know who that is, or Jennifer, hand up. Is that a question? Maybe. Okay. If you got a question, I see hand up again. If you got a question, pop it in the Q&A, and we'll do our best to answer the questions as well. So you do need to disclose that you have contingent funds. The reason why you disclose it is essentially you're telling the seller, when you sign this contract, I have enough money to purchase this contract or this property. I'm gonna make it work. I'll either have a loan in place, I'll have money in a briefcase that I can drop at escrow on the last day. I'll have some way of figuring it out. And if you sign the contract saying, don't you worry, I might have the money tomorrow, that's not contracting in good faith unless you disclose the fact that the money is contingent or somehow not guaranteed. And so use these disclosure forms, the general addendum or the contingent right to purchase, to disclose contingency in that fund. If it's a contingent right to purchase, you have to sell your house first, use the contingent right to purchase form. If it's just generic contingent funds, use the general addendum. Section 28 is the proof of cash funds section. Same thing applies. If the buyer says, yeah, I can buy this in cash, don't worry about it. The buyer needs to prove that they have cash funds. That's one of the first elements of this. It's section 28. It says, buyer, you need to provide reasonably satisfactory proof that you have cash funds. However, beyond that, the buyer represents that they're not relying on contingent funds or non-liquid funds unless they specifically set it forth in this agreement. You can do that in additional provisions, things like that, or in an attached general addendum or Form 2.10, buyer's contingent right to purchase. That is where this contingent right to purchase comes in as well. If the buyer says, I'm going to buy this house in cash, I don't need a loan, that's great. But if the buyer says, I'm going to buy it in cash, don't worry, the cash will arrive just before I buy this property because I'm selling my house currently, a seller can say that's not satisfactory. That's not a proof of cash funds. You need to be able to actually guarantee that I have some sort of an asset that you can pay for this property. Otherwise, we have a very risky, very tenuous transaction that we're proceeding with. And so use these disclosure forms to disclose this information up front. If you're a buyer or a buyer's agent, you want to make it absolutely clear to the seller how you're getting the money to purchase the seller's property as readily and as early as you can. Generally at the offer stage, this should all be understood and known. It shouldn't be something where 3 days into the transaction you go, oh, right, by the way, seller, heads up, we have a contingent transaction now. That's a material change to the contract, is generally a breach. It's something that could result in a termination, so don't do that. Have these contingent rights planned out and agreed to at the moment that you actually have mutual acceptance, not something you enter into down the road. The contingent right to purchase is built into this contingent right to purchase is reductions of risk, specifically risk reductions for the seller. The contingent right to purchase is made limited to a certain extent. The seller can continue, by limited, what we mean is the seller can continue to market the property. It becomes something that the seller can keep on kind of showing to people. This is done by making it in your MLS bumpable, or whatever your local MLS's designation for that is. Section 6 of the contingent right to purchase essentially says, seller, you can keep marketing this thing, keep it on the market, keep accepting offers, keep letting other people put offers on this property, because if they understand and they make an offer and they say, yeah, I'm making an offer contingent on subject to the contingency of the previous buyer, then you're good to go. It's basically a backup offer built on the contingent right of that seller, or of that original buyer failing. And that's acceptable. You can continue accepting these third-party offers. When the seller does accept a third-party offer, and we'll go into this in depth, they're going to send a notice of intent that essentially says, okay, buyer, it's time. Fish or cut bait. Are we moving forward with the transaction, or are we not? If the answer is, you can't make this work, you didn't get an offer on your house, we're going to proceed with this third-party offer, and I'm just going to let you go. We're going to terminate the buyer's transaction and go with the consistent and more kind of solid offer of that third party. That's what the subsequent offer section means. In the MLS designation, this is where we say, seller, your property should be listed as bumpable or some similar term once you've accepted this offer from a buyer that is contingent to something. In some cases, this will be active subject to contingency. I've got a slide next that shows all the designations that you'll see around the state. But in this case, the seller's property should be listed, if it is still advertised, it should be listed as subject to one of these types of contingencies using that MLS designation. This indicates to the world, heads up, this transaction has a relatively risky offer that's currently attached to it that's based on the buyer's offer succeeding. If you're a buyer that really wants this property and you're not super concerned with potentially not getting it because the buyer or the original buyer on this property's deal is contingent, you can put an offer on it and maybe it'll work out for you or maybe it won't. It indicates to the world that this is a possibly risky sale for the original buyer and that subsequent buyers might get the house if they get lucky. Beyond that, if there is ever a notice of intent, which is where you kind of solidify the deal, if you get a notice of intent that says buyer is proceeding with the transaction, seller is immediately supposed to switch the property over to pending. So it's bumpable as long as the contingent right is live. Once the contingent right disappears, the house transfers over to pending. The seller's agent should be the one switching that over to pending on the MLS. And that's when you sort of close the book on being able to accept subsequent offers that aren't just straight up backup offers that have nothing to do with the contingency. When we talk about the contingent right to purchase, there are various terms you'll see around the state. Accepted offer with bumpable buyer in the RMLS, active bumpable in the Willamette Valley MLS. Some places will say active contingent property. I wasn't actually able to figure out which one that was in the state that does it, but in general, active contingent property is what other states will talk about this as. In the MLS, Central Oregon MLS or the Oregon Data Share Flex MLS stuff, they call it active with contingency. And in some cases, they just say contingent. And that's in the Intermountain Region MLS. All of these terms mean the same thing. It means you have a transaction with a contingency attached to it. The buyer's contingent right will exist for a set period of time. The buyer has until a specific date, the contingency deadline, to utilize their contingent right, basically be able to get out of a transaction when their deal stops working for them. If they go to that contingency deadline, the buyer will then release the contingent right at the end of that time frame. So you have until your contingency deadline. Let's say it's, what is today, March 17th, 18th, March 17th. If your contingent deadline was on March 17th, you as a buyer can terminate until the end of March 17th based on your contingent right falling apart. You can just say, sorry, nobody's putting offers on my house. But after that deadline hits, either party gets, or both parties, buyer and seller, get 2 days that they can terminate based on this failed contingency deadline. If nobody terminates within those 2 days, then we just say the contingency has been released. It's gone. It's not there anymore. So the contingency is something that both parties act into if they want to terminate. If the contingency deadline passes and there is no offer on the house, the buyer should absolutely be terminating because they don't have financing. If the seller is uncertain about the buyer's financing and they don't want to go through the rigmarole of getting all the way to closing only to find out that the buyer says, I don't have any money, sorry. The seller should terminate. And at the end of that contingency deadline, both parties get their option to terminate at that point. If you do terminate based on this, we'll get to it. The earnest money generally goes back to buyer. The buyer needs to list their property. This is one of the things in that contingent right to purchase. If a buyer has an offer with the seller that is accepted as a contingent right to purchase, this buyer needs to then list the buyer's property. Buyer needs to list their own personal property shortly after entering this agreement or currently have it listed. You have a little checkbox in section 5 on the contingent right to purchase that says either buyer's property is currently listed and is ready to be sold, or buyer's property will be listed very soon, 5 business days, blank business days, after the seller agrees to this. Buyer is going to keep it listed until the sales agreement is terminated, until the contingency deadline passes, or until buyer provides a notice of intent that says, I want to keep going, or I don't want to do this transaction anymore. Basically, buyer is going to keep this thing listed until the contingency ends. They will make sure that this thing is marketed and it's purchasable until the contingency is gone. The buyer is not required to accept any offer that comes along. It isn't some, when you have a buyer that's listing their property under a contingency, it doesn't mean that the first person that comes in and lowballs that buyer suddenly gets the house and they got lucky because this buyer has to sell it. The buyer doesn't have to accept any old offer, but the buyer also can't just accept any old offer. The buyer has limitations on what offers they can accept. Specifically, the buyer cannot accept an offer that is subject to a further contingent right unless they have the seller's prior written approval. What that means is if the buyer's offer is contingent, the buyer's property cannot, like the second buyer, can't also create a contingency because we're creating a daisy chain of contingent rights. And that's a problem unless the seller is okay with assuming that level of risk. So why do we stop the buyer from accepting a contingent right on the buyer's property, subsequent property? This is the illustration. Seller selling their property to the buyer. It's great. They have a contingent right. The buyer needs to sell the buyer's property. Buyer's trying to sell property to buyer two, buyer squared. Buyer squared has a contingent right where buyer squared has to sell buyer squared's property to buyer to the third, buyer three. This is the daisy chain we're talking about. You have a contingent right between seller and buyer, and now you have a contingent right between buyer and second buyer. And third buyer over here is the possible weak link in the chain. So let's say buyer number 3 is military. They get deployed, I don't know, to Germany or Europe or something like that. They don't need to buy this house anymore. That creates a problem. You are now breaking the contingent right for buyer 2. Buyer 2's deal fell through. Buyer 2 can no longer purchase buyer's property because their buyer 2 property fell apart. That then breaks buyer's deal, and that destroys the whole process. You essentially, the issue that you run into at this point is the daisy chain has broken because of buyer 3. Now, if you're the seller and your deal falls apart, not because your buyer met someone that was sketchy, not because you found a sketchy buyer, but because the buyer's buyer found a sketchy buyer, that's the point where we would rather that the seller give approval beforehand than just make that a default. So in these cases with a contingent right, the buyer cannot have a further contingency unless it has seller's approval. Now, if you're a seller and you approve of the third buyer being on the contingency, in theory, you can approve of a fourth buyer and so on and so forth until you create a full link of people that are all trying to buy each other's house. But usually the seller should only be willing to go about one stage out on their contingent right. It becomes much too tenuous after you get one for a contingency out. So that's why we say buyers, if you're going to have a contingent right on your personal property that must be sold before you can purchase, get the seller's approval first. It's assigning far too much risk to the seller that the seller had no control over and has no control over. And it's not fair to the sellers. It's not even fair to the buyer at that point. It's just kind of a general problem if you've moved that many links out on your contingent right. If the seller does get a better offer or another offer or an offer that's just less risky, the seller can accept it subject to the buyer's contingency being released. This is the buyer giving up their contingent right. This is where Section 6 comes in, and Section 7, subsequent offers, seller will be able to advertise. We saw this one earlier. They'll be able to advertise and do all kinds of stuff. They can accept third-party offers. After receiving, if they get a third-party offer, they are supposed to promptly notify buyer with a Form 2.11 Notice of Intent. We'll get to the Notice of Intent. That indicates that seller has accepted a third-party offer. They got a better offer. They got another offer. It's wonderful. The seller is so happy. They send this Notice of Intent. The election deadline then begins. After the buyer receives this Notice of Intent from the seller, that indicates that seller has gotten a third-party offer, the buyer has until 5 p.m. the next business day, that's their election deadline, to sign and return the Notice of Intent, indicating that they either intend to proceed with the transaction, they're going to release and give up their contingent right and move on with the transaction, or the buyer can just terminate during that election deadline timeframe. They can say, sorry, didn't work out. I'm glad you got another offer. I'm happy for you, but I wish it was me. If there is no response, the seller can just terminate the transaction for 2 days after the election deadline. So the way to think about it is you've got a contingent right deadline and an election deadline that can both be moving simultaneously. And if either one of those deadlines hits, the seller is allowed to terminate for a couple days afterwards. So the seller will know if the buyer's offer fell apart. If they want to accept another one, they'll know. And you'll have 2 days to terminate your transaction with the contingent buyer. Let's see. Buyer's failure to respond, allows seller to terminate. Form 2.11, this is the Notice of Intent. We'll get to it. It has a couple other uses that the buyers have on this one. The Notice of Intent is Form 2.11. It can be used by sellers to say, buyer, fish or cut bait, like move on. Or the buyer can simply use it to say one of 3 things has happened. I got an offer, a written offer, and it's lovely, and I'm going to have this offer ready to go, and I'll sell it, and I'll have money, and I can buy your house, seller, so let's get rid of this contingent right. Stop accepting offers because I have got financing has been secured. Or the buyer can simply use the Notice of Intent to release the buyer's right to terminate under the addendum. They basically say, I don't need the contingent right anymore. Nobody's willing to buy my house, but it turns out I'm independently wealthy. I'm some, peanut heiress or something along those lines, and I have money in spades. So I didn't need the contingent right in the first place. I figured it out. Financing has been secured, and I don't need to sell my house first. You can just get rid of your contingent right. Or in the third case, the buyer can say, it's not working out. I need to terminate and end the contract. Those are the ways that you would use your notice of intent. Buyer uses it to indicate success of the contingency, to release the contingency, or to end the contract. If the contract is terminated by the buyer using the Form 2.11, or if the contract terminates because buyer never returns or provides the Form 2.11, buyer keeps the earnest money. So this is what happens upon termination. Buyer's earnest money is refunded if the following happen. Buyer is not in default under this sales agreement, and buyer indicates that they intend to terminate before the deadline or the election deadline, or the contingent deadline or the election deadline. So the buyer just says at some point, yeah, this isn't working out. I don't want to do this anymore. I'm not in default. Everything's fine. I just don't think I'm going to be able to sell my house. And it turns out I like living here, or something like that. That then allows the buyer to keep the earnest money. Contract's over. No harm, no foul. Alternately, if the buyer fails to provide a notice of intent, the seller sends their notice of intent, says, hey, you need to respond. You have a day. I found a better offer. If the buyer doesn't answer and the seller terminates within that 2 business day period, or the buyer terminates within that 2 business day period, at that point, buyer keeps the earnest money. Essentially, no harm, no foul. Notice has been given. Failure has occurred. We've terminated the contract. If the buyer is in default under this addendum or under some other part of the sales agreement, so the buyer is, for example, forging banknotes and the seller finds out about it, and then the buyer goes, actually, I want out. I'm not doing my contingent right anymore. The buyer doesn't necessarily get their earnest money back. They can't just use it as like an escape hatch to run away from their own misdeeds. So if the buyer is in default, at that point, seller is keeping the earnest money if there is some reason for termination that happens because of the contingent right. So buyers, if you're doing a contingent right because you're putting a lot of risk on the seller and you're taking the seller out of the market based on a very risky transaction, make sure your nose is clean, because if you are in default under the contract, if you're doing things wrong, if you were supposed to, send notice, if you were supposed to get some, clean up the house after the inspections were done and you didn't, you left a giant hole in the yard where you dug a hole to look for an oil tank, something like that, you're in default at that point, and your options are either cure that default, fix it, or maybe you're going to owe the seller the earnest money because you put the risk on them and then did a sloppy job of acting under your contractual rights that you agreed to in the purchase and sale agreement. The timelines, and this is one of the provisions to really pay attention to, timelines remain unchanged unless the parties specify otherwise. So Section 11 of the contingent right to purchase. Unless the parties agree otherwise in a written addendum, all timelines, contingency timeframes, deadlines, and closing dates of the sales agreement shall remain unchanged. Buyer should ensure that sales agreement timelines are adjusted based on the intended sales timelines for buyer's property. Essentially, if you're a seller and a buyer, you have a buyer and a seller that go in on a contract and they say, yeah, we want to sell this property to the buyer. Buyer wants to purchase it. It's subject to the contingent right, buyer selling their own house. Your normal standard is for the next 10 days, the buyer should be doing inspections. If you have a buyer that says, I want to make sure that my house sells first before I waste money on inspections, if my house falls through and I did an inspection, that was useless for me. It means nothing to me. If that's the case and you have a buyer that is not concerned, that is concerned about those expenditures, adjust your sales timelines accordingly so that you can accommodate whatever timeline the buyer needs to feel comfortable with the sale of their personal property that is the contingency in this transaction. The default assumption is not that the buyer's contingency will fail. We assume that if a buyer is putting a deal down on a purchase and sale agreement, they are selling their property and their sale of the buyer's personal property will be successful. We don't build these contingent rights assuming that everything is just going to go disastrously and set the timelines for once buyer finally closes their property, whatever it ends up being. We set it as though everything was going fine, everything will be great. You just move the timeline normally. If your seller or buyer doesn't want to deal with repairs or diligence inspections or with ordering a title report or any of those things until after the contingency is released, specify that in a general addendum. Failure to specify could result in a buyer paying for inspections and then having the property fall through and then not purchasing this house and having just purchased an inspection on a property they won't own. So keep this in mind when you set up your timelines. Normally, if the buyer feels very comfortable with the sale of their personal property, that will finance this process, no problem. You can have your 30-day closing and no one is injured. If it's something where the buyer says, I've got an offer on this one and it's really sketchy and I don't know if this is going to work out, move your timelines to accommodate the sketchiness of the buyer's financing at that point. Remember, the buyer has to act by the earlier of the contingency deadline or the election deadline. Whichever one ends first is going to be the point that provides the ability to end the contract. So if your contingency deadline ends March 17th at 5 p.m., but on the morning of March 17th, the seller sends in a notice of intent and says, I got a third-party offer. How cool is that? The election deadline would technically take them until March 20th. That 5 p.m. on March 20th is the end of the election deadline because that's 5 p.m. the next business day, but your contingency deadline ended at 5 p.m. on the 17th. At that point, even though the buyer has technically received this notice of intent and they have a day to respond, the seller might still terminate based on the failure of the contingency deadline. You're already past your contingency deadline. So be aware, the two rights exist and they aren't necessarily going to play, like one of them is not always the end point. So if you have a contingency deadline, when you hit that point, either party can terminate. It's like, and if nobody terminates, it's like the contingency never existed. If an election deadline does pop up, someone says, hey, a seller says, hey, here's my notice of intent. I got a third-party offer. How great is that? The buyer doesn't respond within that 1 day. Seller is given 2 days to terminate, 2 business days. If the seller doesn't terminate, then you proceed until your contingency deadline, or if this was something that would happen after contingency deadline, then that's like the contingency never happened in the first place. So your election deadline can end, and if the seller doesn't choose to terminate at the end of the election deadline, it doesn't just remove the contingent right. That will happen at the end of the contingency deadline, but the election deadline can also be something that is curtailed or shortened by the contingency deadline. I hope I didn't confuse people on that one. With that, notice of intent. That's what we're going to talk about next. Form 2.11, this is the fish or cut bait document. Essentially, once you get it, your option is to fish or cut bait. Notice 2.11 is the way that you can indicate either that the seller has received an offer from a third party that they want to accept, or a way that the buyer can notify the seller that they either want to keep moving with the transaction and just get rid of this contingency, or that the buyer does not want to do this transaction anymore and they are going to terminate. The notice of intent has 2 parts to it. The first chunk is the top part, sections 4 through 7. It is the seller's notice to the buyer. If the seller sends the notice of intent and they've checked this little box on section 4, they are indicating that they have received a third-party offer. And they have that third-party offer contingent on buyer's offer, but they would like to accept it. Buyer now has 24 hours, well, a business day rather, to respond to this notice of intent by sending it back with the buyer's section, the second lower half of the form filled out. There also is a section here, section 6, for the delivery date, where you can say when it was delivered. This is what provides the proof that you have for when your election deadline ends. If the delivery date is, for example, March 17th, 1 business day later takes us over the entire weekend and on to Monday. Monday ends at 5. That's March 20th. So March 20th would be your end of the deadline, election deadline, but that would be based on the delivery date of your notice of intent. And seller signs this. The buyer doesn't need to sign seller's side of the letter of the notice of intent. The buyer's notice to seller is everything section 8 and below. So the document has a line on it that goes seller's side is all the stuff on top, buyer's side, all the stuff below. The buyer's notice, same form. The buyer can use the notice of intent sent by the seller to respond, or the buyer can send the notice of intent just straight without ever getting one from the seller. The buyer provides the copy of the signed notice of intent to the seller at any time before the earlier of the contingency deadline or the election deadline. You have those 2 time frames that dictate when your contingency is happening. So the earlier of those 2, and buyer will be bound by whatever they check on the rest of the document. We'll get to it. If buyer is sending their notice of intent, they must send it before the earlier of those days. Be aware, pay attention, know which of your timelines you're dealing with and which one is going to kill that contingent right first. The notice of intent itself has various selections for the buyer. This is notice of intent. There's also a notice to terminate. We'll get to that, but it's the checkbox is on section 9, intent to proceed. The buyer can either say, I have an offer that has been accepted on my property. How wonderful. This is lovely. I have financing secured. It's going to be great. The buyer's accepted their offer. They're going to keep the seller informed of all material changes related to their ability to close the sales agreement. So if the buyer finds out halfway through, they're like, whoa, turns out the third party buyer, the second buyer, they're not as secure as I thought they would be, and it looks like the deal is going to fall through. You need to tell the seller immediately, as quickly as possible, keep them informed of that material. The buyer, by signing this notice of intent and checking this box, is releasing their right to terminate based on the contingent right to purchase. They release all of their contingent rights except for the contingency of the sale. So essentially it means the buyer can no longer say, well, I can't do this anymore. I don't think my property is going to sell. If you check this box on Section 9, you are no longer allowed to say, I don't think my house is going to sell, so I want out of the deal. It's the way of locking you in. It's when the deal goes to pending rather than staying bumpable. If there is something that goes wrong, the buyer needs to promptly notify the seller when the buyer's property deal is terminated, so buyer 2 is not able to continue the transaction. At that point, tell the seller, and now you've got a decision for what you're going to do. Do you terminate the sales agreement? One of the parties can, two parties can just terminate the contract within the next 2 business days, or do you negotiate a procedure for the parties to take in lieu of termination? So if you don't terminate the deal, you got a couple days, figure it out. If nobody can figure out what to do, either party can simply terminate the transaction. At that point, the right to terminate is unlimited. It goes on until the end of the transaction. So if the buyer has a contingent right, they find an offer, it's successful, buyer is going to sell that house, they love it, it's wonderful, buyer checks this box, they release their contingent right to purchase because the buyer has got a buyer, and that's going to be wonderful. And then the buyer's buyer fails. The buyer has to tell the seller, and now the parties can determine what they're going to do. They can either terminate or they can try and figure it out. And if they can't figure it out within 3 business days, then either party can simply terminate the transaction for the rest of the contract because that buyer is not consistent or guaranteed. So it creates a very tenuous contract if you have a contingent right purchase that falls through. If the buyer's buyer is not secured, your contingent right and the whole contract becomes much more unstable. It's built on pillars of sand at that point. Be aware. Now, if nothing goes wrong with the buyer's buyer, lovely. There is no contingent termination right that is unlimited. But if the buyer's buyer fails, your contract becomes very, very uncertain. Buyer cannot accept an offer on buyer's property subject to a contingent right to sell or a third party to sell a third party property without seller's written approval. This is repeated again. It's important. Please don't daisy chain your contingent rights. It creates problems. The other option that the buyer has on the intent to proceed is just releasing the contingency. They just say, you know, nobody accepted my deal on the property. Nobody accepted it, but I don't care anyways. Let's just move on with the transaction. Turns out I've got enough money to pay for it. If the buyer checks this second box, they are releasing all of the contingent rights and they're proceeding with the transaction. And they will either figure out proof of cash funds sufficient to seller. They will do that within the next 2 business days, or they'll provide written evidence from their lender that buyer can get a loan on this property. So if the contingent right falls through, the buyer will have what amounts to is promptly is defined in our contracts as soon as possible, but no more than 2 business days. They will have up to 2 days to be able to show the seller, yeah, I wasn't able to sell my house, but I can still finance this transaction. I can still purchase. I can prove to you that the lender is okay with it. I can prove to you that I have enough cash on hand. I can prove to you that I can buy this house. The notice of intent for the buyer's side, the intent to proceed, takes you in 2 directions. Either the buyer's has no offers yet, they agree to release the contingency and have to find some proof of cash funds, or they have an offer that was accepted, money is there, they have enough to purchase the transaction. That's what Section 9 is used for. Either one of these situations. I can figure out how to pay for it, or I can already prove to you that someone put an offer on it and I can pay for the property. The third option that the buyer gets is the intent to terminate. This is Section 10. So Section 9, if the buyer checks one of those boxes, they say, hey, it's all going great. We don't need this contingency anymore because I have figured it out. Alternately, Section 10, if they check this box, the buyer is saying, I can't do this anymore. Sorry, I'm going to terminate the transaction within the next 2 days. I'm going to send you the notice of termination, just giving you a fair warning. You're going to see a notice of termination real soon. And we're going to refund earnest money to the buyer because the buyer's house is not getting offers, because all the offers are low balls, because someone that was looking at buyer's house fell through the staircase and they figure out that's going to be a $50,000 repair, something along those lines. All of those possibilities, those potentials, those concerns, those can lead to a buyer simply saying, it's not going to work out, so let's terminate the transaction. I don't want to leave you on the hook forever, seller. Be aware. You're going to terminate this real soon. But giving this note intent to terminate is the buyer's way of essentially saying, here, stay tuned. We're not going to have a transaction very soon. If the buyer just wants to go straight to termination, they can also go straight to termination if there's a reason for it. But this is the way of essentially granting the buyer the right to terminate the contract by sending this notice of intent back. So, summary, if you want it for your files, if you want it for this one to put up on a training for your brokerage, here are the 3 ways a buyer can use the notice of intent. Hey, I have an offer on my house too. I don't need the contingent right anymore. Financing secured. Hey, my house hasn't sold, but I still want to buy your house and I'll find a way to figure it out. Or, hey, this isn't working. I need to terminate the transaction. Those are your 3 options for a buyer in a notice of intent. The contingent obligation to sell is what we're going to talk about next. This is the last of the 3 forms. The contingent obligation to sell is a contingent contractual provision that bases the contract on the seller finding a replacement property. So the seller locating something to live in after they sell their house. If the seller does not find the replacement home, they can terminate the agreement. The contingent obligation to sell is a protection that is given to sellers. Essentially, it's sellers giving it to themselves. They kind of award themselves a medal in the contract at this point. And it allows the seller to guarantee that they will have a place to live after the sale. Now, why does it feel like the sellers are given a whole bunch of protections and buyers not necessarily in these forms? It's because the seller is the one selling the house that owns the house, and the sellers generally have the right of contracting. So that means the seller gets to pick if they want to sell their house or not, and if they want to give themselves extra protections, so can the seller choose, because the seller is the one controlling the actual thing being sold. They are the contractee rather than the contractor. So they don't have to be the one that sends the offer and says, please make this work. The seller can be the one that says, it's only going to work out if the following things are true. In a different market, you won't see these contingent obligations to sell ever. If the buyers are in absolute control, don't expect many contingent obligations to sell. It is inherently risky for a buyer to be involved in a transaction that is subject to a contingent obligation to sell. Be aware. The deal can fall through no fault of the buyer or the seller. It could just be that the seller can't find a replacement home. Turns out there's nothing else on the market. Even though the buyer has done everything right, the deal might fall through because the seller doesn't have a new place to live. Buyers beware when a contingent obligation to sell is attached, because it is inherently not buyer friendly. The clip art example of a contingent obligation to sell is impossible to show, so this is my best option. Is a seller trying to sell their house but doesn't want to live in a van down by the river? They can cut the contract. They can turn it around and say this is not happening anymore. That is what this is. It's the I don't want to live in a van down by the river kind of approach to contracting. The contingent obligation to sell itself allows the seller to terminate the agreement at any time before the deadline. There's a contingency deadline that's set in this. Now, please note, if you have a contingent right to sell and a contingent right to purchase and a contingent obligation to sell on the same contract, you're on thin ice in the first place, but you can do that. You can have a contingent obligation to sell and a contingent right to purchase simultaneously on the same house. It just means the seller's got to figure their stuff out, and the buyer's got to figure their stuff out on the other side of the table. Those 2 contracts, they have different contingency deadlines. They're both technically called contingency deadlines, but they're referring to different things. So that's the one overlap in language, is if you have a contingent obligation and a contingent right that both bump into each other, the word contingency deadline is not accurate enough or specific enough to really tell you which one you're talking about. So if you're ever referencing it in emails, if you're telling someone, hey, our contingency deadline's coming up, if you've got that obligation and right simultaneously, say our contingency deadline under the contingent obligation to sell, or our contingency deadline under the contingent right to purchase is coming close to being done. So specify. More specificity is always good. The contingency deadline in the contingent obligation to sell is seller may terminate the sales agreement by delivering a seller's notice of termination to buyer, explaining that their contingency failed due to seller's failure to enter into an agreement to purchase or to failure to close on a replacement property, as indicated above. We'll get to the indications. At any time before 5 p.m. on a set day. That means the seller can terminate at any point before a set day. The parties can agree to extend the contingent deadline if they want to, but they don't have to. That has to be signed by both parties. If the seller does get to the contingency deadline and hasn't terminated, the contingency, this contingent obligation to sell, is considered released. So essentially, the seller is granting themselves a right to unlimitedly terminate the contract until a certain day, and when that day hits, they can't terminate anymore. But until that day happens, the seller has this right to terminate based on failure or fall through of their contingency. I see a question in the chat that Jeremy is answering, sort of, but I want to bring it up as well. How do we make sure that seller really did not find a replacement property? Couldn't sellers abuse this contingency, let's say, by terminating their sale because they have or hope to have a better offer? The answer is technically yes. There is a requirement that I'll get to in this where there is an obligation of good faith on the seller's part. That's technically a common law as well. It's not something that's like removed from the sellers. They can just use this to cheat buyers, but because the seller should be trying to find their replacement property. But if the seller doesn't try really hard, or if the seller tries marginally hard, but they could have tried harder to find a replacement property, there is technically no loss under these contract terms. Is it something that can be abused by sellers? It could. It could. The reason why that's a problem for a lot of buyers is that you're usually in a market that's not buyer friendly, but that's kind of how these contract provisions seem to work is if a seller puts it on the contract and a buyer says, I'm willing to buy this property subject to this contingent obligation, the buyer is assuming a significant amount of risk. And if the buyer is not comfortable with that level of risk, the buyer should not try to accept the deal, the counteroffer, the offer from the seller that has this contingent obligation attached to it. Would we suggest that buyers put these contingent obligations to sell in their contracts just generically, like a buyer's making an offer to a seller and to really sweeten the deal, they put a contingent obligation to sell in? You can. Is it advised? Not from a risk management perspective, not really for a buyer's agent. We wouldn't necessarily say that's a great move for the buyer to make, but if the buyer is really doing everything they can to make their offer as absolutely golden as they possibly can, adding this in could be something they do, but the buyer must understand by adding a contingent obligation to sell, they are putting in a significant amount of risk where they might lose this transaction, they might lose this house through no fault of the buyers, through potential misdeeds of the seller, through all kinds of problems that can occur. It simply is something that makes the contract less consistent. If you don't like these contingent provisions, inform your buyers what they mean and assume most buyers will be reasonable and say, I don't want to take a risk on that. I'd rather have a house that I can guarantee. So it's the answer that I can give here is not exceptional in that it says this is risky to buyers, but buyers don't have to take on the risk because you never have to agree to a contract that has this in it. The seller can set the end point to the contingency. So you've got the deadline, the contingency deadline, where it just cuts. It's done. It's over. But there are also points where the contingency deadline will stop. It'll be contingent upon various things. When you reach this point, your contingency should be released. It should be done. The seller can choose which one it is. Is it acceptance of an offer on a replacement property? Seller put an offer down. They said accept. Well, there's still 30 days or so that things could go wrong. So you might not want to trigger the end point to your contingency based on that. Is it release or waiver of inspection rights? Is it waiver of the appraisal contingency or receipt of a satisfactory appraisal? Did you appraise it? And it's like, yeah, it's great. The loan will work. This is going to be wonderful. Is it the seller successfully closing on the replacement property, or is it some other time frame? Is it 20 days after mutual acceptance? You can set up whatever you want as a seller. This essentially allows you to say, when this point hits, my right is gone. Even if we're, several days before the contingency deadline, if I do this thing, I have successfully closed the replacement property, the right is over. If it's acceptance of the seller's offer on a replacement property and the seller just thinks that it's going to go great, then that is what it is. The seller is expected to be working and operating in good faith, is what we said earlier, at all times to fulfill the contingency. The provision, this provision heads up the one that Section 7, good faith efforts. It has limited impact, but it does technically expressly say, seller, you got to be working on this. In this section, it states the seller agrees that the seller shall make a good faith effort to make an offer on a replacement property that is sufficient for the seller's needs, and agrees to make good faith efforts to successfully close on the replacement property where a seller's offer is accepted by a third-party owner. So if the seller has their offer accepted, if the seller is looking for properties, technically they literally under the contract are supposed to be doing their best to make this work. Now, what if the seller does not do their best? The reason why we say this provision has limited effect is it's really hard to prove that someone was not making good faith efforts in the first place. That's a gray phrase. It doesn't really mean all that much. It means, try your best, but, circumstances can get in the way. And it becomes very, very, we will be sending out copies of the slides and we will post the recording of this up on the website as well. So On orforms.org in the training tab, we have various pre-recorded videos for the various trainings we've done. This will be on there if you're curious about termination. We have a video on that. The differences between Oregon Realtors and OREF forms, we have one on that. We have one on vacancy addendums. Every week we'll have one of these trainings that we do that will pop up onto the website as well. So be aware, it'll be posted. And Katie, can I get a confirmation that we're going to post the slides as well? The PDF, or I've got a PDF that's just all the slides. Now in that PDF, the weird clip art stuff isn't going to mean anything. There's no description of what this is. So it's possible you look at this a couple weeks later and it's just hieroglyphics, and I apologize. But all the other information is in the PDF for you there. Oops. Yeah. So good faith efforts, the reason why it's kind of a squishy provision, we say it has limited effect, is it's really hard to prove when someone has made good faith effort to do something or not. And it's really, really difficult to win that lawsuit. Technically, you could argue if a seller is not operating in good faith that that's a problem, and therefore they're in breach of contract, and therefore the buyer should be entitled to the earnest money if something goes awry. If you can show that the seller signed a contingent obligation to sell and then proceeded to leave on like a safari for the next 3 months for the entire time frame they were planning to be looking at other property, yeah, you might have a good argument that this was not a good faith effort. But if it's just something where the seller is looking on Zillow and nothing pops up that strikes their fancy as a sufficient replacement for their needs, it's not for the buyer or the buyer's agent to decide what fits the seller's needs. And that's why we say it has limited effect. It's not something that any lawyer would want to argue in a court of law. It's technically there for those really fringe circumstances where you can just prove malicious and egregious failure of good faith. But everything in sort of the gray zone of good faith, unless you have really nice evidence, you're not going to be able to prove that. But it's here. So sellers, do your best. You know, I think in Japanese it's gambate, or say gambate. It's something like that. Do your best. Or work hard. We believe in you. That kind of thing. So please, try the best you can, sellers. If you're going to do a contingent obligation, don't just, hold the buyers over the fire because you can. Find a replacement property. Beyond that, the seller can also establish the timelines that you begin the timeline on. So it can be, for example, all timelines, contingencies, timeframes, deadlines, closing date, and sales agreement begins upon the occurrence of seller's selection in Section 3. So, for example, normally you have 10 days to do your inspections on the property, that kind of thing. Or the seller has to order a title report the day after mutual acceptance. If you check the first box, it might be seller doesn't have to order that preliminary title report until the seller successfully closed on the replacement property. It might be that seller doesn't have to order the preliminary title report until the seller has released the satisfaction or been satisfied with the inspection reports on the replacement property. Essentially, it delays all of the action. It puts everything on ice. It freezes everything until a slightly further date out. And the seller can choose the occurrence of their selection in Section 3, or they can choose successful closing on the replacement property. In theory, you could also set it up as all timelines begin immediately upon acceptance and mutual acceptance of the deal between seller and buyer. If you put it in this section, you could theoretically trigger the end of the contingent obligation immediately, but then you've defeated the purpose of your contingent obligation at that point. So seller can choose when all of the time frames begin, when they move forward. Last things to point out, if the seller's contingency ends upon acceptance of the seller's offer, you don't revive it if that offer falls through. So if seller's contingency is based in Section 3 upon successful acceptance of seller's offer and then it falls apart, the seller can't later on come back and be like, well, so that offer didn't work, but I put an offer on another house, so my contingent obligation remains. Once you've fulfilled your contingent obligation, this Section 3 thing, the first time, it's over. You don't get to have it back. The seller only gets one bite at this contingent obligation. They can have their right to terminate until the occurrence of that thing they've chosen. If the seller is more concerned that the contingency should be the closing of they want to actually own the replacement property before they give up their contingent right, you can choose that. But if the seller puts it at offer, once the seller has an accepted offer, they have met their contingency. They don't get it back. The last thing to point out is if the seller does terminate for whatever reason during this contingent obligation to sell, earn his money back to buyer. There are some situations where this could be different. For example, if the buyer is in default, the buyer has done something truly egregious and wrong, there could be arguments that the parties can have that the seller is entitled to the earnest money. But generally speaking, if the seller is terminating because of the contingent obligation, earnest money back to buyer. If the seller is terminating because the buyer has done something egregious, but they're using this contingent obligation to sell as their reasoning for it, then we've got an argument. There's discussion that can be had about that. But generally speaking, if the seller's only reason for termination is that the contingent obligation timeframe has not ended, therefore seller wants to terminate, the buyer gets the money back, the earnest money back. That is all we've got on the contingent rights and forms. If you've got questions, pop them into chat, pop them into the Q&A. I'll do my best to answer them at this point. If there are things we want to go back over, we can do that. Otherwise, that is our training for today. And we've gone the full 52 minutes now. So this is something that you'll get your CE for this. Katie, I believe, guarantee me on that one. We say 1 week to 2 weeks for CE. I'm not certain about the exact timeline, but we should get that out to you at some stage. But I'll remain on for the next 5 or so minutes. And if you've got questions, please put them up in the chat and we'll do our best to answer them. If you've got general questions about other things, just let us know. If you've got comments on the forms@OregonRealtors.org. That's where you can let us know what works, what doesn't work. We've had people tell us the forms are hideous, that they look god-awful, and they want to see more beautiful white space on the forums. And if that's the case, let us know. We want to hear all the commentary back from people. If the process that we've explained for the notice of intent seems confusing and you've got suggestions for how to improve it, let us know. We are open to as much feedback as we possibly can get. And keep in mind, Legal Hotline is now available to all of you guys. So if you've got other questions related to other legal concepts, shoot us an email at legal@OregonRealtors.org, and we'll do our best to answer it within 24, a business day. On the contingent right, we got a question. On the contingent right to purchase, can buyer cancel any time within the contingency deadline without using property disclosure period or inspection contingency? Yes. So if there is a contingent right to purchase that is up, the buyer can simply terminate based on that contingent right to purchase. Now, that termination is different from the revocation that would come with the property disclosure statement. The seller's property disclosure statement gives the buyer a revocation right, which is technically different from a termination right because you don't need mapped escrow instructions. If you send a revocation based solely on the property disclosure statement, escrow can just send the money back. They don't need to ever hear from the seller. It's a weird thing that only happens in Oregon. On the other hand, if you're terminating as a buyer based on the failure of you just say, I can't do this, terminate based on the contingent right to purchase, the seller does need to respond to that termination. So you might have a dispute about earnest money, and that just comes with the process of the termination itself. But to answer your question there, Sean, yes, you can terminate. Nanette, I appreciate the compliment, I really do. And then Mickey, I have a question about the failure of the financing contingency. Seems like the seller would choose to terminate even if the buyer is offering to make up a low appraisal with their own cash. Is that correct? So if with the financing contingency, if the buyer's appraisal comes in low, that is automatic. It's something that allows the seller to terminate. Now, the buyer can request to modify that appraisal contingency and say, hey, let's wheel and deal on this one. I think I can make up the difference. But the seller doesn't have to agree with that difference. It's one of the things built into the actual financing contingency of the purchase and sale agreement is if you have a low appraisal, the parties can negotiate, but there's no mandatory requirement that you approve of a buyer making gap payments on that appraisal. So seller could, the answer is yes, Mickey. The seller could choose to terminate if the buyer appraisal comes in low, but they don't have to. The parties can wheel and deal. I believe that's section 27 of the purchase and sale agreement. It talks about the entire process of a failed financing contingency and what you're supposed to do when one of those things falls through. It essentially says buyer can terminate and be like, it didn't work, sorry. Or if they don't terminate at the time they say this didn't work out, the parties will take a short period of time, I believe it's 3 business days, where they will negotiate. You have to renegotiate for 3 days. And if at the end of those 3 days nothing has been reached, seller can terminate at that point. So while a buyer's low appraisal doesn't automatically grant the right to terminate, it will soon if nothing is figured out. Karen, I see question, if the seller terminates because they can't find a replacement property, but the buyer has already accepted an offer on their home, what happens to their transaction? So if you have a seller that terminates because they have can't find a replacement property, and the buyer simultaneously is selling their house, so you have that contingent obligation and contingent right to purchase at the same time. Uh, if that buyer's contingent right to purchase is not simultaneously contingent, or I guess if the buyer doesn't have a contingent right to purchase in place, the buyer might just be on the hook, is what it comes down to. So if you have a contingent obligation to sell and your buyer can only finance the purchase of the seller's property by selling their own house, but the buyer chooses not to use a contingent right to purchase, which then makes it like a somewhat flexible sale process with the buyer's buyer, that buyer might just be in trouble because they haven't contracted for their own protections in that case on a risky contract with that contingent obligation to sell. It's not an exceptional answer because it does leave the buyer sort of holding the bag. But what that means in this case is if you have a buyer who has to sell their own property to afford the seller's property, and the buyer wants someplace to live, the buyer should have their own contingent obligation to sell that they do with their buyers on the buyer's property. So you can, a daisy chain of contingent obligations to sell is not the wrong decision. But that would be the privity of that obligation to sell is between the buyer and the buyer's buyer, if that makes sense. Let's see. I see a question. If you are a bumpable contingent status as a seller and the buyer accepts an offer on their house, then does the buyer's agent need to send the notice of intent that they are moving forward without that contingency? So if you are in bumpable status as a seller, buyer accepts an offer on their home, so you've got a contingent right to purchase where buyer says, I need to sell my home first. At that stage, buyer doesn't have to send the notice of intent, but they really should. And if the buyer ever gets to the contingency deadline without responding, without sending a notice of intent that says, look at it, I got an offer, how great is this? The seller still has a right to terminate that is granted just by failure of the buyer's notice of intent by that timeline. So what essentially, it's the, this one. If you've got a buyer who finds a property and you are at some time before on this timeline, you're at some stage before this deadline, at any point if the buyer's offer is accepted, congratulations, buyer. That's great. You should tell the seller. The seller's going to want to know immediately because things can still go wrong on these contingency deadlines, and a seller is granted a pretty wide-ranging ability to terminate if things go wrong. So tell the seller as quickly as possible. It puts you into pending, and then the seller doesn't have a chance to get a better offer than the one that your buyer has. But if you don't send your notice of intent, by the time your contingency deadline hits, you should have sent it. You need to have sent it by that point, or else the seller can just terminate the transaction. So kind of an answer. My answer is it depends, and I would say generally the risk management is as soon as you've got this offer on your house as a buyer, send the notice of intent to the seller because that takes this seller's property off market. It puts it into pending, not into bumpable, and that notice of intent is what triggers the seller putting it into pending. All right. Jeremy's going to be on the open house. If people have general questions, I don't remember what topic he's covering today, but the open houses are getting somewhat shorter in how much we do with them. They're not for CE anymore, but if you're interested in just general information and 1 hour about forms wasn't enough for you, we've got another hour right behind. And this one is the open house. As time goes on, will just be questions and answers. If you've got curiosities about forms, please pop into the open house, ask us those questions. That is the place where we're hoping to gather as much information, make responses, teach people about forms, and also help people with kind of gathering information that needs to change into the future. If people come in and they say, I need a party wall agreement, let us know because we haven't drafted one yet. We haven't heard enough requests to have that, but down by the river, yeah, that it took me way too long to come up with a way of kind of talking about a contingent obligation to sell, and living in a van down by the river was the only thing that popped to mind in the end. I hope these work for you. We'll get these slides, these presentations out to people as well, so you'll have the PDFs of the various presentation slides. Keep in mind this will also be on the website, so if you want to watch the presentation again, slow it down to 50% speed so you can hear me talk like a regular person. That's on the website as well. Otherwise, it's 11:01, and we appreciate all the time and interest that people have put into these forums. Thank you so much for your time, and I hope you guys have a good rest of your day, and happy St. Patrick's Day. Wear your green. And